SJC-12790, in the matter of an impounded case.
I got to really break some kid that really still. Ms. Caddick, good morning.
Good morning. Chief Justice Gants, may it please the court, Elizabeth Caddick for the juvenile, and with me is Michael Kilkelly, trial counsel. Juvenile sex offender registration does not work. Year after year, state after state, it's been proven that it does not lower the risk to reoffend. It does not lower the risk of first-time offenses. The registry's ineffectiveness is shown across all states and the federal government, and no fix to the registry statute is going to fix the fact that juvenile registration.
Any of that in the original record here?
Yes.
Are we doing this totally abstractly? Was this presented down below?
Yes, it was, Your Honor.
Was a contested evidentiary hearing on all of this?
Well, there was a contested evidentiary hearing on his relief for registration.
On this individual, but is there any contested evidentiary hearing on all of this global study issue that it's unconstitutional for all juveniles? Do we have an adequate record to make such a determination?
Yes, we do. The fact that it wasn't contested by the Commonwealth does not defeat the juvenile's argument. The juvenile submitted a research information by his expert. His expert did an evaluation. She discussed in her written report the low risk to reoffend among juveniles and attached to her report a detailed affidavit of the low risk to reoffend of juveniles, citing to all of the empirical research, and also attached to it the harms of registration. She discussed the low risk to reoffend at the hearing and specifically said that this boy's risk to reoffend, low to moderate using a tool, was compared to the already low risk of juvenile sex offenders. So she said it was low to moderate compared to a low risk to begin with. So that was in the record, in her report, in her affidavits to the report, and in her testimony at the hearing.
Did the judge take it that way? Did Judge Bussman take it that way? If he took it that way, I don't understand why he would say that it was just the low to moderate risk.
Because what he said was that with the requirement that by LL, he said he was constrained, that he accepted everything the expert testified to. He agreed with everything the expert testified to, but said at the hearing and in his written findings that he did after this case was taken on reservation and report, he stated that he was constrained by the requirements of LL that it be less than low.
Right, so what I'm saying is what you just said is that it should be less than low, right?
Well, yeah, that's the argument, but that's not what the court.
But you're saying, Justice Kafka asked you what was in the record, and you just said that it had to do with the expert's report, and that the expert's report was credited by Judge Bussman.
Right.
And Judge Bussman said that it still was low to moderate, because he felt that that was what she said.
Well, what he
Wrong, or was he number one, was he wrong in the way he construed the expert's
Right.
report or recommendation? And number two, in terms of LL, did the judge incorrectly apply LL?
Oh, I don't think he incorrectly applied LL. I
That's
think he
what it
was.
says.
I think he abused his discretion in not finding that the juvenile was less than low. He specifically stated that the expert testified that it was low to moderate compared to the low rate of.
That makes it
sex
less than
offenders.
low.
Well, he didn't conclude that it was less than low. I'm arguing he should have, and so.
That's what you think the expert says. It's less than low.
Well, the expert didn't say it was less than low. The expert said it was low to moderate compared to juveniles who have a low rate to reoffend. And so the court, she did not say that it was less than low. And also it's difficult for experts to say that there is any such thing as less than low, because if you look at all of the assessment tools, including the ones that work for adults, say the static 99, there is no such thing as less than low. So to have an expert say something is less than low, I think the problem with LL is because of the fact that it's asking for an expert or judge or even SORB to find out that someone who committed a sex offense is now less than low. We know that the juvenile sex offense rate is less than 5%, particularly in recent years, now that we know that all crimes, including violent crimes, are lower. So the most recent research is that it's 2.7 to 3%, the reoffense rate, and that juveniles do not commit juveniles who are adjudicated of sex offenses do not commit sex offenses at a rate any higher than any juvenile or any adult.
Are there any studies indicating what happens when the juvenile is out of the juvenile system and they're an adult? Is there a translation?
Oh, absolutely, absolutely. They have follow-up studies that go for up to 20 years, although what they found is that if someone has not reoffended within the first 3 to 5 years, they're not going to reoffend at all. But they have looked at studies that go 20, 30 years, and they find that for adults, 30, 40 years hence, any of them who have committed sex offenses had not committed a sex offense as a juvenile, and none of the juvenile sex offenders committed a sex offense as an adult in this one particular study that went on for 30, 40 years. That's the Cambridge study by Caldwell and others. So we know there's no correlation, there's no ability to predict whether someone is going to commit a sex offense as an adult by the mere fact that they committed a sex offense. And this is state after state, and year after year, tens of thousands of cases. There is no study that has found that registration lowers the risk to reoffend.
But doesn't it allow people to have a sense of, if someone's on the registry, that gives people a heads up that this person has had a problem in the past. So it may not mean that there's any a higher rate of recidivism, but it does give people a chance to stay away from that person.
It means nothing. I mean, the fact that a juvenile committed a sex offense means nothing about their risk to reoffend sexually, because we know that juveniles who are not on the registry and juveniles who are on the registry, when you control for the type of sex offense they committed, their age, and the amount of time of follow-up, that there's no difference between someone who's not on the registry and someone who is on the registry as far as reoffense rate for anything, for sex offenses or any type of offense, violent offense.
Once you're on the registry as a juvenile, how hard is it to get off of it?
Well, first, if I could just address the harm to even be on it in the first place. Because once you're on it, even putting aside the internet dissemination, which I know this court knows is extremely harmful. And
Before you go there, could you?
Yeah.
I just want to follow up on Judge Spud's question, though, because I'm
Okay.
not sure do those studies control for the effect of being on the registry? Because you're more heavily monitored. People are more aware of you. Do those studies control for the possible effectiveness of the registry?
Yes, because what they have done is they've, especially now that we've had the registration for about 20 years, they've looked at it in South Carolina, in New York, and they've looked at what the rate of reoffense was before, for 10, 20 years before registration, and what it is for 10.
No, but mine's a different question.
Okay.
Because you have to, unless the registry, I understand you think the registry is useless, but it has a deterrent, it has an effect in the sense that it's more difficult to commit another offense if you're on the registry because people are aware of, I'm just trying to understand, do those studies control for the fact that it may be harder to commit an offense if you're on it?
Exactly, because there are studies that, are retrospective and look at it, but there are also prospective ones that follow the same type of juveniles who commit the same type of crime, who are on the registry and who are not. And there is no difference in the reoffense rate
What do we do with that, though? What do we do with the fact that these studies that we're referring to weren't offered before Judge Blitzman, as I understand it? You'll tell me if I'm wrong. They weren't cross-examined. There was no Dalbert Lanigan hearing as to them. What do we do with that in making this decision?
Well, this court has a rule before that it doesn't matter that studies were not admitted as exhibits below. It can look at social science research to determine whether in fact, what SORB is doing is constitutional. It did that in the cases involving age for those 61 and older, or for females. And it looked at all the recent research that has come out since then. And
when that happened, was it an issue that had been raised in the trial court first?
Well,
the constitutionality of the issue? Because I don't even think this constitutional issue was before Judge Blitz.
It was. In fact, the juvenile argued at trial that it's a violation of procedural due process and a violation of his right to...
Trial, I thought he pled.
No, for his motion for relief from registration.
that one.
He argued that that he should not have to register because of the low rate of reoffense and because of the punishment that someone who is on registration suffers from. And he said that it was a violation of due process.
As it relates to him.
No, he said all juveniles. And in fact, the single justice had argued that below. He said that he and no juvenile should have to register. And that was what was reported to this court, is that the juvenile is asking for a broad declaration from this court that no juvenile should have to register as a sex offender because of what we know about juvenile brain development and because it's a violation of due process. And
So it's an as-applied, or is it a facial challenge to both of the...
it's as applied to juveniles, the Sex Offender Registry Board is unconstitutional. It violates procedural due process because there is no amount of procedure that is going to accurately predict what a juvenile's rate of reoffense is. And one of the reasons is because their reoffense rate is so low, none of the research results are statistically significant. The other reason is because of what we know about juvenile brain development. They mature out of their offending behavior. We also know that juveniles do not commit sex offenses because of some type of paraphilia or some type of mental disease that leads them to commit sex offenses. It's because they're juveniles.
Right, but that, just going back to my question, once you're on it, how do you get off of it? Because if a juvenile is, doesn't have the paraphilia stuff, if they're still committing sex offenses, the public should know to stay clear.
Well, if they are still committing sex offenses, if they're one of the very few, the 2.3%, then we already have laws to address that. Anyone who commits a sex offense, particularly a violent sex offense, we have youthful offender laws where they'll go into DYS until they're 21 and have an adult sentence along with it, where it's a suspended prison sentence. Probation usually begins right at the time they're sentenced, so they're on probation all through DYS.
So, but your argument as to juveniles would apply to youthful offenders also?
Yes, it does, because the juvenile brain development applies to youthful offenders, just as it applies to murderers, first-degree murderers, armed robbers. This court has already applied it, so it's the same argument. To get off of registration, the problem is you're asking the Sex Offender Registry Board that has its own regulations that have not been empirically tested, that have no ability to predict what someone's risk to reoffend is, and you're asking them to say he's less than low. And it's really impossible for even the empirically tested juvenile risk assessments, the ERASER or the JSOB, which are used really to determine what type of treatment a juvenile should get because of either the type of sex offense they committed, their history of a disruptive life, perhaps their mental illness. And that gets me to what does work. If we want society to be safer, and not just feel safer, because there's this ineffective, counterproductive registry. But if you want society to actually be safer, then what you offer these juveniles is counseling. There have been research after research shows that counseling such as dialectical behavior therapy, DBT, works to not only lower reoffense rates for sex offenses or any type of reoffense, it lowers any type of behavior such that it lowers the rate of them having out-of-home placement. It lowers addictions. It lowers abuse of illegal substances. And so that's what will help society. And DYS does give DBT therapy. It gives it to all juveniles who are there twice a week, and those who are there for sex offenses get specific sex offender treatment also.
Does it make a difference whether on a liberty interest or a privacy interest as to what level somebody's classified at? I mean, what difference does it make to somebody who's at level 1 as opposed to 2 or 3? Now, we know 2 or 3 is going to be awful, right?
Right,
But level 1,
but even the
how is
level-
that a terrible invasion of somebody's privacy if nobody other than the police know about it?
Well, okay, first of all, the punishment that would be involved.
What is the punishment, though? We never said
well,
there was punishment.
The punishment, well, first of all, the punishment would be being subjected to being charged with failure to register as a sex offender because you don't jump through all the increasingly difficult hoops involved with registering as a sex offender and having to give notice 10 days before you move that you're moving, and your secondary address, which is, when you spend more than 4 days in any year at one particular address. And you can be like this juvenile who's considered so safe that all he has is probation, not sentenced to DYS, but if he commits failure to register, he can be sentenced to prison. And so that's a punishment. But we also know that even juveniles who were not on the internet also suffer from 4 times as frequent suicide attempts than those not on the registry. They're twice as...
Irrespective of what ranking they have, 1, 2, or 3?
Yes, because this was the most recent research by Letourneau and others who looked at 12 different states and whether they were on the registry or not and whether they were on the internet or not. And because even though someone's a level 1, the people within their sphere often know that they're still on the registry. The schools know, the police know. There's also what's called the scarlet letter effect, where those who are on the registry, even level 1s, are arrested more often for any type of crime, particularly low-level property crimes. And they're not convicted of those crimes, though. So there's not enough evidence to convict them, but because there's hyper-surveillance of them, they're arrested more often. And so that is the punishment, and that is what they suffer.
Let me ask you a question. On level 1s, if a juvenile is able to get the relief of after a hearing, which is what is provided for a hearing, let's say after a year or so, whatever, is it subject to being sealed?
If it's a level 1, you mean they're convicted?
I know that the problem with level 2 and level 3 is
Right.
that once it's on the internet, it's never going to be off the internet.
Right.
But I'm just saying that I think that level 1, it's not going to have the same public consequences necessarily.
Well, they're youthful. If they're juvenile adjudication, then
Right,
it
then
won't
they
be
could
open
be
to the
sealed.
public. YOs, they can't be sealed because of the sealing statute. They prohibit
Okay, that's
sealing
YOs,
sex
but what
offenses.
about the juvenile delinquency?
Excuse me?
What about delinquency?
If it's adjudication, then
Yes.
then the public shouldn't have access to it.
Right.
Right, so that would be the same as being sealed, but that doesn't, they still, other people will get it. The Corey law requires an increasingly different number of levels of access to Corey, landlords and jobs and just
Be able to get to the fact that the level 1 registration was required?
I'm
And
sorry.
are you saying all these effects would happen to somebody who is a level 1?
Yes,
Why?
because they controlled for all that in the study. They looked at.
The statute basically says, the sealing statute, the Corey, that this is a criminal offender registration information?
Well, what the statute says is that those who are ever a level 2 or level 3 cannot have their crime.
Yeah, all right, what about level 1?
Well, I don't believe there's a statute that says a level 1 can or can't have it sealed, but if you're a level 1 and you're a youthful offender, there's a Corey statute, a separate one, that says that sex offenses can never be sealed. So it's going to be there anyway. But all of the deleterious effects of registration will be there with someone who's a level 1, as there is someone with a level 2 or level 3. I don't think there's any dispute that any juvenile on the internet has a worse outcome than someone not. But that does not mean that we can say that a level 1 juvenile does not suffer and does not have, and gets procedural due process, because it's still so inaccurate. It'll never be a accurate classification. It also harms society by having too many people who have no risk to reoffend on the registry. It saps the resources of the police and the registry board from evaluating people who really have a risk, or the adults who have a risk, by having all these juveniles who have such a low risk we can't even determine what it is. Even someone who commits a violent offense as a juvenile, they still cannot predict what their reoffense rate is, because the reoffense rate is so low.
I have one question before, I know your time is up. I read the plea colloquy. He never admitted to the facts here. It was an admission to sufficient facts. Is that sufficient for a finding of delinquency?
Well, I understand what you're asking, and I've been seeing it more frequently in juvenile cases, and I'm not prepared to answer that question, but I do see that, and I don't know the answer. I could follow up if the court wants with a post-argument research.
If you wish to.
Oh,
I just
sure.
wasn't sure that, I know that this was viewed as a finding of delinquency.
Right.
But in fact, all that the juvenile admitted to is that there were sufficient facts to support a
Right.
finding. He never said, I did it.
Well, I'd be glad to research that, Your Honor.
Okay, thank you.
Thank you.
Ms. Silverman.
May it please the court, my name is Elizabeth Silverman. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. The Massachusetts Registry Act is constitutionally sound in its inclusion of juveniles because it recognizes and incorporates the difference between adults and juveniles in its evaluation and classification of sexual offenders. Juveniles are simply not treated the same under the Registry Act. They are first, all juveniles are given the opportunity to move in the juvenile court for relief from registration.
How long do they have to wait to do that? What's the time period?
Within 14 days.
Okay, no, I'm talking about once they've been classified, they can move for reclassification or getting taken off, right? The registry?
Sure, I was even before that,
Go,
Justice.
no, I
Yes.
understand. I get it. Go ahead. Sorry,
Okay,
I
so
didn't
if
mean to
they-
cut you off.
If they are not relieved by the juvenile court, they are then reviewed by SORB. And when a juvenile is reviewed by SORB, they must be reviewed by a board member who is either a licensed psychologist or a psychiatrist who has expertise and experience in juvenile sex offenders.
Can I ask you a different kind of question? I understand that there are these procedures that you say are protective of juveniles, recognizing the difference between juveniles and adults. But the question I have is, in the past, at least in terms of age and gender, SORB's regulations have not exactly kept pace with the research that's out there. And that's one of the things that SORB was criticized for. Has SORB kept up with this research?
The SORB's most recent regulations issued in 2016, and they
Acknowledge that is there agreement or disagreement with what she's saying about the inability to measure or inability to predict? Are you in disagreement on what the research shows?
I think the research is speaking to the individual tests, like the psychological instruments that they don't predict, because juveniles are always changing and that there are static factors that don't apply to them, and also that these these studies talk about, or usually talking about reconviction as opposed to reoffense. And we all know that, particularly with sex offenses, that the rate of reoffense is higher than the rate of reconviction. So two
How do
things.
we know that? How
But
do we
two
know
things
that?
to answer to that is that SORB uses a much more expansive way of viewing, of making these determinations, whether a sex offender poses a danger to the community that warrants registration and dissemination. It looks at the entire history of the offender, his family, his psychology. It's not based on one test or one predictive factor. With the case,
I think what's being argued, though, is that the research is showing that there are no such things as predictive factors. There's no way of measuring whether a juvenile is going to be a reoffender, is what I think she's saying that the research shows. So that this whole system can't work. It's just impossible for it to work, I think, is the ultimate.
that can always be made even with adults, that you can't, that you can't, it's not a crystal ball, but that we know that applying what we know about factors that contribute to reoffense, we make the best judgment that we have. And while juveniles have a lower risk of reoffense, what the studies don't say, and what this court should not find as a fact, is that will never be the case, or that there isn't ever a case of a juvenile who poses enough of a danger to the community such that he should be part of the registry.
I just want to go back a step. How much of this was before Judge Blitzman? I mean, we're talking about a bunch of studies here. Were they all before Judge Blitzman? Was any of this,
Was this just sort of added to affidavits, or was this a contested issue?
No, not at the hearing. So in the juvenile's motion, he argued in a summary fashion that the constitutional issue. At the
the
hearing,
constitutional issue being that we should declare the entire registry unconstitutional for all juveniles? And what was submitted, was that issue joined? I mean, what happened on this? Because I understand this can be extremely complicated. And this court, for example, on sex said, okay, well, you've got to analyze women differently than men. And we sent it back for a thorough review. But has any of this been tested, analyzed in this case? Or is this just like was this a throwaway line in a case about this individual that no one focused on?
it's much closer to what you're describing.
But so tell me what happened.
So what happened was there was the motion for relief, which did contain that one paragraph that contested the constitutionality of the statute.
And were there 1,000, was this a Brandeis brief with all kinds of studies attached and analyzed? Or what happened below?
No, it was just a paragraph of that motion.
And then what studies, like your sister has brought up a bunch of studies. Were those studies before Judge
No,
Brixman?
so then when the hearing took place, there was an expert who spoke about the risk of reoffense as it applied to this juvenile. And the Commonwealth and Defense Counsel made argument with respect to this juvenile. And the findings of fact that were made were with respect to this juvenile.
So
There was
so
not
I
any
asked-
conversation about the
I want
constitutionality.
to go back to that, because I asked the appellant's attorney, I asked Ms. Caddick, was the issue of the constitutionality of juvenile sex offender registration argued at the hearing? And the answer I got was yes.
It was not argued at the hearing, although it was submitted in paper at the hearing. It just wasn't something.
And were these studies attached to that piece of paper saying, you know, there are 55 studies that declare that juveniles don't reoffend any higher, they're actually lower than all other. Was that before, I mean, Judge Blixman's a very thoughtful juvenile court judge, so was any of this before him?
No, There were no studies submitted. There was a bibliography that referenced some studies attached to the expert's report. The expert did not refer to those studies. The sole focus of that hearing was the risk of reoffense of that juvenile.
And he did not make any rulings of law on that point either, right?
No, he made extensive oral findings into the record at the time that he decided this in April.
He filed something later, correct?
Yeah, so then this case went to the single justice, and when Justice Budd reported the question to the full bench and this case had entered this court, he then went back and filed findings of facts, additional findings of fact on this issue, which the Commonwealth asked the juvenile court to strike, but he declined to.
The expert at the hearing said that this individual had, I believe, a low to moderate rate of risk among juveniles, correct?
Yes.
So in terms of the board, when it determines whether the risk is low, moderate, or high, are you determining that it's low among juveniles, where juveniles themselves have a lower rate, or that it's just low and that's the same implicit risk for adults as well as juveniles?
LL was a case that was decided in the context of juveniles. So a low to moderate risk among juveniles means a low to moderate risk.
Why is that? Because juveniles have a lower risk than adults. I think you conceded that point.
She was speaking that juveniles have a low risk and this juvenile has a low to moderate risk. I don't...
Among juveniles, I thought. I thought that the actual testimony said there's a low moderate risk with regard to other juveniles. Am I correct?
That's correct. And the way it was interpreted by Judge Blitzman was that that means a low to moderate risk.
Okay, but isn't that wrong? I mean, if the average rate of adult recidivism, say, is 8 or 10%, I forget the precise numbers, and the average rate for juveniles are 3 to 5%, and again, I forget the precise numbers, but I know that they're considerably less than for adults, then wouldn't a low to moderate rate among juveniles put you into a 2 or 3% range, as opposed to a low to moderate risk among adults, which would put you, say, in a 7 or 8% range?
Potentially, and at best that it's not clear, but the way that the judge interpreted this was that the juvenile had, that the expert had recognized that there's a low rate of recidivism and that this juvenile presented a low to moderate risk.
Okay, but I guess what I'm saying is with regard to, assuming this person does go to SORB, when SORB is calculating the risk, does it say low, moderate, or high among juveniles, or low, moderate, high, period?
Low, moderate, high.
Period.
Period.
Okay, so it could be that the vast majority of juveniles are going to be viewed as either low or below low risk if the numbers that are presented to us are accurate.
That's correct.
Now, we're in sort of this strange world. We call this case Commonwealth versus Juvenile, and it's impounded, but the issue is whether or not the individual will be permitted to be included in the sex registration registry, and if he's a level 2 or level 3, the world will know his name. How do we deal with the conflict between our statutes, which say that all juvenile cases are impounded and sealed, and the sex registration statute, which permits them to be, if found to be a level 2 or 3, to be disseminated on the internet?
So in the rear circumstance where after the individualized reviews, a juvenile sex offender is determined to pose a high enough risk to be a level 2 or a level 3, the legislature has determined that where these laws intersect, that the public safety wins out, and that in this circumstance, the need to disseminate that information is more important than keeping that privacy only for as long as the juvenile is on the sex offender registry.
You say rare. Do you have data to indicate how rare it is?
At the last, one of the amici did a public records request to the Sex Offender Registry Board to ask about the current number of juveniles. This is outside the record, but it was asked by one of the amicus. And of the 11,500 members of the people who are on the sex offender registry, only one is a juvenile, and he's a level 1.
Ms. Silverman, as far as what studies are out there, I think we know from studies that sex offenses are one of, if not the least reported crime. Do we know anything about when the juvenile is the perpetrator, whether or not you have lower rates of reporting? Because I would expect that some significant percentage of victims in those circumstances are juveniles as well. Are there any studies out there touching on that?
The court is correct in that this is a very underreported set of crimes. Whether it's less reported when a juvenile is the assailant, I'm not aware of any.
Now, going back to the legislative history, I have a memory that this particular sexual registration law was done quite hastily in order to avoid the loss of federal funding. Am I correct?
There was a precursor to this law which was already in effect. So, in fact, it wasn't, the amendments may have been done in short order, but it had already been conceived.
But the scope of sex registration for juveniles in Massachusetts is considerably greater than that which is required under federal law, isn't it? Or that which is required to avoid a penalty under federal law.
And the due process that's given to juveniles is also greater.
Okay, but am I correct that under federal law, the federal law would mandate, at the threat of losing federal funding, only that there be registration of those who committed an aggravated crime of sexual assault?
Of someone who's 14 or above and an aggravated, essentially follows somewhat loosely our youthful offender statute.
But this individual actually would not fall within that. His crime was a statutory rape, would not be an aggravated.
No, and it's also not yet been determined whether this individual should have to register at the registry and what that classification would be, if any.
Okay, thank you.
No, can I just make an observation here that I'm looking at Justice Judge Blitzman's findings and rulings, and he seems to rely on a good deal of the research that we're talking about.
At the hearing, he candidly said that he had done some of his own sua sponte research in making those additional findings. And I
So
think
those
that-
studies, and I was curious about that too, all those studies he's citing, after the single justice report, he goes and does his own research. He doesn't bring in any of these experts to testify or anything. This is all based on cases, sort of research represented in the Ohio and the Pennsylvania Supreme Court decisions?
Exactly. Research that simply couldn't be done in Massachusetts because we frankly don't have that many juveniles on the registry.
And let me ask you the same question I asked your sister. Is there any consequence of the fact that this particular juvenile only admitted to sufficient facts and did not admit to his own guilt?
I don't believe so. That's a practice in the juvenile court that's akin to that which is done in the in the district court, the admission
In
of...
the district court, it's called a quaff. But this is called a finding of delinquency. I mean, the plea colloquy that I saw was basically appropriate for a quaff. It's not appropriate for a finding of guilt.
Although the...
Is that the custom in the juvenile court? Do you know?
I think, again, that varies from court to court and judge to judge.
Is there any,
It's not
is there
the
any
first time
consequence that we don't have any admission by the juvenile that he actually did the acts that he's alleged to have done? That all that he admitted to was that a finder of fact, viewing the evidence in the light most favorable to the Commonwealth, could find sufficient facts to support a finding of delinquency?
I don't believe the finding of whether he poses a danger to the community such that he needs to be included in the registry or whether he should have been relieved from that obligation hinges on the fact that he is admitted to these facts or not. So no.
Okay.
Thank you.
Thank you. We'll take a morning break.